The United Nations is currently facing an issue of sexual exploitation by its peacekeepers against the very population that they're sent to protect. This is not an isolated problem, and it's not a recent one. Peacekeeping operations have been plagued with sex-related misconduct off and on since the early 1990s. Allegations include rape, sexual violence, exchange of sex for small amounts of money or food, and paedophilia. They have been reported from almost every area in which the UN operates. So just to give you an example, that's Cambodia, Côte d'Ivoire, Democratic Republic of Congo, Haiti, South Sudan, Somalia, Chad, and more recently the Central African Republic. And victims, they're most likely women and children. Since 2003, the UN's response has been supposedly one of zero tolerance. Despite this strong position, the UN does not currently have the capacity to initiate criminal investigation or enforce prosecution. In the particular case of military contingent personnel, the largest category of personnel, it is the troop contributing countries that have exclusive criminal jurisdiction. Total reliance on the troop contributing countries to investigate and prosecute their nationals has arguably resulted in an accountability gap, with perpetrators seemingly going uninvestigated and unpunished. Accountability to this day has been a sore spot for the international community and can be best described as woeful. If contributing states do not prosecute, and the host state is unable to do that because of legal immunities, and the UN cannot enforce that, then the result is impunity. Most importantly, victims cannot enforce their rights at the international level. They're often left in the dark and they're left without justice. The United Nations has had 20 years of tinkering with this system, but have failed to fill that accountability gap. My research revolves around a central proposal, which is twofold. The first is to establish a series of hybrid courts in mission areas, and second, a mechanism for victim rehabilitation and reparations. The proposal is more than just a technical fix of legal ambiguities. It directly challenges the primary role of troop contributing countries to hold their peacekeepers to account. So the proposal goes towards centering the interests of victims and encouraging international cooperation. A hybrid model is the best option for a number of reasons. If you have a trial taking place in the community in which the crime has taken place, the victims will see justice being done, the host state will have some ownership over that process, and the UN will have leadership as well, perhaps through centralising an administrative system for those courts. Having sexual exploitation and abuse prosecuted at the international level will recognise the seriousness of that conduct and the gravity of harm towards victims.